Well, good morning, good afternoon, good evening, whatever is your time where you are connecting. Thank you for joining today's webinar organized by Ally Law. For those of you who don't know, Ally Law is a global network of independent law firms. There's a bit of an echo. These firms collaborate to deliver high quality, cost-effective legal services worldwide. We have over 70 member firms, actually 77, as this little slide says, and it was established in 1989, and there are more than 100 jurisdictions and almost 3,000 lawyers. So all of this to offer seamless cross-border legal support. Member firms are selected for their commitment to excellence and responsiveness. Clients benefit from top-tier legal advice with flexible, transparent pricing. Firms collaborate closely. Ally Law isn't just a network. It's a partnership of trusted advisors who understand your business and deliver results across borders. Ally Law includes different kinds of lawyers. We have the litigators, we have the specialists of specific fields. However, a good chunk of us are transactional lawyers with a focus on M&A. And if, like myself and today's speakers, you're trying to get deals to closing, you may have noticed that FDI clearance is often in the way. My name is Paola Sangiovanni, and I am the president of Ally Law. Thank you, Meg. I am a partner of the law firm Gitti and Partners, which is the Italian member of the Ally Law network. And let me tell you why I think FDI matters today. Governments around the world are tightening foreign direct investments controls, and they want to do that to safeguard a variety of sectors: national security, critical infrastructure, and strategic sectors such as healthcare, artificial intelligence, and energy. In both the EU and the UK, FDI screening regimes have expanded significantly in response to rising geopolitical tensions, supply chain fragility, and the rapid pace of technological innovation. The COVID-19 pandemic further highlighted the strategic importance of sectors like biotech, health data, pharmaceuticals, and medical devices, now firmly on the radar of national security reviews. And as political tensions challenge the globalization of trade, FDI clearance is becoming a standard requirement across many jurisdictions. This makes it an ideal moment to explore how different legal systems approach FDI regulations. And today we have an incredible panel of experts to discuss this with, and we're joined by M&A partners of our China, Germany, and United States firms to discuss this increasingly critical topic. Let's start to introduce the speakers. Let's start from Ning. Ning is our back one. Meg, please. Ning is the managing partner of Chansbridge Law Firm in China, which is a full-service firm with more than 100 lawyers with offices in Beijing, Shanghai, Shenzhen, and Haikou. Ning focuses her practice on cross-border M&A and restructuring, capital markets, and finance. She serves clients in the banking and financial services, manufacturing, media, and a range of other commercial industries. Ning is listed as a highly regarded lawyer in M&A by International Financial Law Review 1000, a legal rating organization for the financial and corporate sectors. Thank you for joining us, Ning.
Thank you.
We have, hi, Ning. Then we have Dr. Bodo Vinnen, who is the partner of Melchers, a 50-lawyer full-service law firm in Germany. Bodo is based in Frankfurt, but the law firm also has offices in Heidelberg, Berlin, and Mannheim. Bodo handles all types of cross-border corporate transactions, including M&A and restructures and corporate compliance. International companies seek his advice on all aspects of commercial and distribution law, foreign trade, export control, supply chain compliance, and money laundering. He is an ICC certified Incoterms trainer and a recommended lawyer by Legal 500 in Germany. We then have Harvey Koning, next, who is a partner at Varnum LLP, a USA full-service law firm based in Michigan, with over 180 attorneys. Harvey advises a variety of businesses and financial institutions on mergers, acquisitions, and capital raising. Harvey worked with international clients, including cross-border investment into the US. He also works with financial institutions and on acquisitions and governance matters where he interacts with government regulatory agencies. He is included in Best Lawyers in America for the banking and finance, corporate and financial services regulation sectors, and is Martin Day Hubble AV preeminent peer review rated. So you can see I wasn't kidding when I said we have a stellar panel to discuss this issue. And let's jump right in and let me ask our speakers the first question. How does FDI work in your country? Ning.
Okay, thank you, Paula, for the wonderful introduction. And I'm so happy to be the first one to share with our audience about the FDI topics in China. I'm happy to start with the first, the numbers of the FDI cases in past years to explain why FDI in China still matters. Because there are so many reports saying that the FDI in China, the numbers reduced dramatically. But if we see the numbers in the past years, actually the deal, the value of the deal is increasing, even though that the number during the pandemic period is lower, but for the value of the project actually is growing. So this is, I think, shows something that even the number is reduced, but the bigger projects become more and more frequent. So this is the trend. Next, please. And then this slides also shows the trend in the recent year. This is from 2024 to 2025. Even though that we can see the figures that the FDI in China, compared to the peak times like 2018, the numbers are still low, but we can see the percentage of the lower number become better. So especially for this year, we only have numbers in April 2025, but in the recent several months, the FDI numbers are growing. So FDI in China is a still hot topic in the market. So that's why we still think China is a good, attractive market for investors. Next, please. Yeah, since considering the FDI in China, we have to understand the basic legal structure of FDI issues. Here I mentioned a very important law governing the foreign investment in China is the Foreign Investment Law of People's Republic of China. This law, I think is very important for every investor to make an investment in China. Is that before this law it become effective in 2020, we have no unified law to govern foreign investment. So before this law, we have three regulations govern the foreign investment into China, which we maybe someone knows that is a wholly foreign owned enterprises, joint venture enterprises, and also a joint corporation enterprises law. So we have a separate three separate regulations, but since 2020, and we have one unified foreign investment law of China. And The second point of importance of this law is that for the foreign investment law, the FDI, like foreign direct investment, like green-led investment, and also the M&A are also included, governed by this law. And the most significant change of this law is that the treatment to the foreign investors and the national investment are the same. So this is the key point of this law. Next, please. Yeah. Next, please. Yeah. Except the regulations, there are also several issues we need to come back, please. The two important issues that related to the FDI in China is that first, when you're considering making investment in China, first you need to decide which industry sector you need to make investment. So for this part, there are two very important concept to understand is that in China, we have a negative list for foreign companies to consider making investment, which means that if the industries like on the negative list, that is the sector either prohibited or restricted for foreign investment to do business. Otherwise, except the sectors listed on the negative list, the other sectors either encouraged or accepted. So that is quite straightforward. And the very significant trend in the recent years is that Chinese government reduced many industry sectors from the negative list. So which means that we have a more open policy for attracting foreign investment come into China. So this is the negative list, very important part need to be recognized. And the second is you need to decide which region is best for your business, right? So in China, where there are uneven distribution of FDI in the market. For the coastal region, which we all know that's leading by the city of Shanghai and Shenzhen, the coastal regions are very mature and very advanced, well-developed land, very high with high personnel, high technology, and the policy is more open. So these places are very, very good for the investment and also attract a lot of foreign investors. However, in the interior regions, maybe not like that attractive. But we still need to bear in mind that there are special zones that specifically attract specific industries. Something like special economic zone. And we also have a high-tech development zone and also free trade zone. So in these special zones, there are special policy, treat the different sectors like high-tech company, life science, or other industry sector that more welcomed by the government. So after choosing the sector and also the region, you need to consider about the types of foreign investment, right? Here, I think for the company structure and partnership are the same with anywhere, but there is a special part you need to bear in mind is that rep office is not allowed to take commercial activities in the market. Next, please. Yeah, the next page is the capital and funding. Meg, please, next page. The registered capital for the company is no difference from other countries. I think for the capital contribution, either you can make a cash or you can make other kind, like intellectual property are all good. But there's only issue you need to consider is that in China, the two concepts need to be divided. The first one is the total investment amount, and the second one is registered capital. That is totally different two concepts. The total investment amount include equity funding and the shareholders loan, but the registered capital is only the capital that the shareholders put into the company as a registered capital, right? So this is the a general concept need to be understood. And also for someone making investment into China, also considering maybe one day I need to exit China, right? So I think for the process is quite smooth and quite open. But there is only one thing to consider is the foreign exchange control. The only way you get your money back is that you need to put your money into China legally. So which means the money in and the money out need to be parallel. So that is a really important issue to understand. So I think this is my general introduction of FDI in China. So I'm happy to take questions afterwards. Thank you, Paola.
Thank you, Ning. We can now focus on a different continent, and let's go to Germany and Bodo. How does it work in Germany?
Thank you, Paola. Yeah, I will give you in the next 6-7 minutes very brief overview about the current legal system on the FDI we have in Germany. So generally speaking, we have a very open investment policy in Germany. So foreign investors are free to acquire companies in Germany. We are very much welcome investors here, even if Federal Ministry of Economic Affairs and Energy may prohibit such a acquisition or impose several conditions on that acquisition if security-related issues are affected. So next slide, please. So I would, Meg, next slide, please. So you need to know that we have two types of investment under review under German law. So the first is a cross-sector review. So which means that we have several, or let's say in a different way, we have or any kind of business can be related by this if especially put on a list which is attached to the legal to the regulation of our law, where several critical infrastructure, high-tech businesses are listed, or even if it is not listed there, even then, if it has an impact on security in Germany and the stable order in our country, then it may be subject to such a review of the German authorities. However, this cross-sector review only applies to investors coming from outside the European Union or the European Economic Area. So from China or the US, but not from France or UK or Norway, for example. UK is not right because they are neither EU nor EEA. So in such cases, the German Ministry for Economic Affairs can look into it, in particular if the transaction or the acquisition of the target's business is listed, as I said, due to the law, if it is critical infrastructure mentioned there, health, IT, media companies, something like that, then you have to notify with the German authority and they have a look into it. If the acquisition is more than 25%, depending on the business, it may also be 20% or 10% at the minimum. So if you acquire 5%, it's always free and you do not have to notify at all. This is a cross-sector review, but you also have the sectoral review, which is military defense-related issues and manufacturers of products with high security functions to process classified state materials. So if these two sectors are in the part of the target's business, and you intend to acquire at least 10% of such target, then you are required to notify the German authorities, and this applies if you come from outside Germany. So regardless whether you are a European or an EEA investor, you also have to notify the German authority. Next slide, please. So if it comes to, as I said, to the notification requirement, then it is necessary after notification was made that the transaction is not completed. If you complete that, it would be seen as a criminal offense, which will be punished really tough by German authorities. And the acquisition is reversed and declared for null and void. So this is something that should certainly be avoided. And so we have from the procedure, the German authority will look into that case, have a 2-month period to check whether it starts or initiate phase 2. That means detailed investigation on that topic. Usually you could say in Germany, I would say 40, I have some figures found. So within 40 days, we have 2/3 of all notification cases are settled without anything and without any, let's say, measures taken by the authority. To give you some some instructions what to do, and 85% are handled after 60 days. So usually you could say this is it, this pre-investigation phase, that's a check, and then it is done. If the authority decides to step in or initiate the investigation procedure, then it will be checked whether security and public order aspects are met here, which may hinder that acquisition or requires any actions to be taken by the authorities. It should be pointed out that no economic, labor market, industrial policy considerations come into play. So we just look purely on security and public order aspects for the question whether or not measures to be taken. As I said, it is possible that after that investigation procedure, the authority imposes conditions or prohibit the acquisition, even if this is very seldom the case. So the authority has 4 months to run that investigation. Only in exceptional cases, the authority is entitled to extend that this time limit. That next slide, please. That should be the overview. I have here given you a summary for what the points I've talking about before. Yes, and thereby that's it, the overview from Germany. Thank you.
Thank you, Bodo. The summary is very clear and nice to have. So the floor is now for Harvey Koning to explain what the situation is in the USA.
Very good. Thank you, Paula. Thank you, Ning. Thank you, Bodo. Now we'll talk a little bit about the USA. I would like to use my time to make some observations about how it works in the USA. And then I will share the most important single thing I want everyone to know in this area to help you with transactions here. And then finally, my best recommendation on how to get your deal done. Similar to Germany and many other countries, the US is very welcoming and open to foreign direct investment. Year in and year out, the USA is the largest recipient of foreign direct investment, and it comes from all over the world. It comes from China, it comes from Europe, it comes from many different countries. In fact, there's about 300 billion US dollars a year of foreign investment, and it involves more than 2,000 transactions. So on any given day, there's $1 billion US of investment and 10 or more transactions. What's curious about the US system is there is a big role for the US federal government, which has the right to review transactions, investigate transactions, and block transactions if there is a concern that the transaction would negatively affect national security. All decisions are based on national security, not economic interests, and that's the focus of it. However, even though the US government has broad authority to regulate transactions and to block transactions, very few transactions are subject to a mandatory filing requirement. We'll get to that in a moment, but only a narrow slice of all transactions require a filing with the federal government to put them on notice and to get pre-clearance. That's maybe only 100 deals a year out of 2,000 plus transactions. In addition to that, if the parties have concerns that there might be an objection, they can voluntarily file with the US government, and that's another 200 or so transactions a year. So about 300 total out of maybe 2,000 plus total transactions. So many investments, but only a few get reviewed. That leads right into the most important point I want to share with you, and that's this. The US government has broad authority to block a transaction that negatively affects national security. That can happen before the transaction closes. It can happen after the transaction closes. Even years later, the US government has the authority to go in and unwind a transaction. It's based on national security interests, but those interests are determined by the US government in its own view, and it is not required to explain the reasons for the denial. And those denials are not subject to any court review. So it's a final US decision. And that's what leads many people to voluntarily file with the US government to get a pre-clearance, because if you're pre-cleared, then the government is no longer able to object. Now I'm going to back up a moment and talk about what I mean when I say the US government objects. The US government has set up a special agency. It's called the Committee on Foreign Investment in the US, CFIUS, which we all call CFIUS. And what that organization is it's a group of 9 different government departments that each have a representative and have input into the process. For mandatory transactions, which would include transactions with critical sensitive technologies, or transactions where a foreign government is involved in the ownership, then there's a mandatory filing. All other filings are voluntary. The focus is on technology, infrastructure, data, and also real estate that's close to military bases and sensitive installations. Let's go ahead and proceed to the next slide. So within those 300 filings a year, some are mandatory, some are voluntary. There's both a short form that's available. If you think it's pretty clear that the transaction should be approved, you can submit on the shorter form, or if it's a closer call, then you need to submit a more detailed long form notice to that. The filings are made jointly by the investor or the buyer and also the company. As I mentioned, most are voluntary. In addition to the nature of the company and the nature of the technology or infrastructure, another key factor is the country. Countries with whom the US has a more complicated relationship, say China or Russia, receive more scrutiny than countries where the US has a friendlier relationship, such as Canada or a number of other countries in the world. Just to give you an example of some of the more high-profile companies that have run into trouble with US approvals, one would be TikTok, which is a Chinese-based company that acquired a US company that became part of US TikTok's operations. And that was a situation where the government came after the fact and put pressure on it to create new different ownership for the US entity. Another more recent one was US Steel, a very iconic, famous US company. And that was proposed to be purchased by Nippon Steel out of Japan, a country with whom we have friendly relationships. That was initially blocked, but later approved. Let's go to the next slide, please. So it's very much a judgment call, both on whether to engage with CFIUS, and that's where good legal counsel comes in. And it's also a judgment call on the part of CFIUS, what they would consider to be a national security concern. And I would warn you, some concerns are obvious. It involves, technology involving encryption or weapons or those sorts of things. But sometimes between the 9 agencies, CFIUS will focus on transactions or aspects of the transactions that might not seem immediately obvious to the parties. So that's what causes some people to file voluntarily. Ultimately, the president of the US has the final say and can block a transaction. That's happened only about 10 times in history, but 2 times more recently, and it may occur more recently in the future as CFIUS gets additional attention. And it's all very serious because even after the fact, CFIUS can cause a transaction to be unwound. Recently, they went back and voided a real estate acquisition from 5 years ago. Some of the more sensitive and more problematic applications or notices to CFIUS are resolved by doing mitigation measures, where the government might require there to be a U.S. citizen board of directors, a U.S. citizen president, a security officer, or some other measure designed to reduce the risk. And that really leads to my final recommendation is, given all the judgment calls involved, the voluntary nature of the filing, and all that, it's very important for the parties at the outset of the transaction to consult with legal counsel that are knowledgeable in these matters, and to develop a strategy specific to the transaction, because the specifics of one transaction may lend in favor of making a filing. Another transaction, you may decide not to make a filing. And as I said, most transactions do not involve a filing. So that's my best advice, is given the very strong powers of the U.S. government, to have a good strategy with good advice in advance. Thank you.
Thank you, Harvey. Very, very nice and very clear presentation. So we'd like to take advantage of the fact that many of our attendees today are lawyers from across the globe, and would like to launch a survey question on how long does the FDI process typically last in your jurisdiction, to get a sense of how long this takes in a cross-border deal. That is something that many of us have to manage in our professional lives. Meg, will the answer come up?
Yes, absolutely. Just a minute,
Thank
yeah.
you. Yeah. Meanwhile, we can move on to the second segment of our talk event today, which is we're trying to get a sense of how frequent is the need of the FDI clearance, and if it's more frequent than in the past. I can speak about the Italian legislation. For sure, after COVID, FDI is a lot more pervasive, and we've seen a spike in FDI submissions that used to be reserved for specific industries that are very strategic, and now, for example, in healthcare, which is the sector which I work in mostly, is very, very common. So let's go back to our speakers with this question. Is the need of an FDI clearance more frequent than before?
Okay, thank you, Paula. I think I will also start the first to explain the situation in China. As I mentioned in the first part, that for the new foreign investment law coming, so the negative list reduced a lot of industry sectors. So which means that the government attitude, to the foreign investment is more open. So for this reason, the reduction of the FDI clearance is very significant, and that is very helpful for the foreign investment, and especially for the new company to register an entity in China. The process is very short. It's the period is very short, and the process is very simple. So that is a very significant change part. However, there are several issues we need to pay attention to, that for a certain industry sector, there are issues related to the national security review, related to the data protection, especially for some sensitive data that related to people's personal information and some numbers related to the specific industry. This information are very are very sensitive and should be clarified before transfer from China to overseas. So this is and also the export control issue, because for the manufacturers, if you have products in China need to be sold overseas, and need to consider the export control issues. So for these several specific issues need to be really pay attention to. But generally speaking, the FDI clearance is not so heavy that before. So I think this is good part. For the requirements of FDI clearance, next slide, please. There are several specific approvals we need to pay attention. The first one is pre-approvals. That is a very general approval, like names and other things. But specific approval is related to the industry sector, which we have already mentioned. If there's something related to the negative list, there's either pre-approval or the shareholders restrictions. So this is something need to pay attention to. And compared to the pre-approvals, there are also two regular matters need to understand. The first one is the annual filing. Every foreign invested entity in China, there's a need to make annual filing to the registry office. This is the requirements. And the third one is the post approval, which means, for this special sector, you need to report the shareholdings, report your business scope. That is only for the specific sector. So this is for the general approvals. There's the other issues are related to this national securities review and antitrust review. That is also the issues needed to pay attention. Especially for national securities review. Next slide, please. Okay, for the antitrust review, there is a very clear threshold for companies making investment and to reach certain numbers or certain size, you need to apply for approval. So that is the antitrust review. For the national securities review, if there's anything related to the foreign related to the military industry or military related or supported sector is fall into the national security review. So that is a very clear stated. However, for the practice, even though the regulation makes clear, but still, when you have a case, you need to consult the lawyers or maybe special consultant to have a clear guidance about the national security topics, because this one is a very complicated topic, especially in the recent 1-2 years. So I think this is end of my part. Thank you, Paola. I give back to you. Yeah.
Thank you, Ning. So I think you touched on this, Bodo, in your presentation before. Would you say FDI clearance is becoming more frequent?
The answer is yes. So, I mean, if you look back some years, you see that the EU Commission has in 2019, or we have in the EU so-called screening regulation in place, which established a system or a mechanism of information between the member countries and the EU Commission when it comes to the let's say critical business sectors and acquisitions in that part. However, it is not required by any kind of a regulation, EU regulation, for member countries in the EU to have FDI regulation in place. So we have 3 countries currently, which are Greece, Croatia. It's not Croatia, it's not EU, but may become shortly, and Cyprus, which have no FDI regulation at all. Germany then in 2021 tightened very much the German regulations, so put in place this huge list of critical sectors, which requires now notification of the German authorities. That's necessary to have, and the thresholds for acquisitions were lowered. So this, in the end, yes, have an impact on the clearance processes and the notifications. In future, there will be, or there's on the horizon, a new EU screening regulation, which makes it then obligatory for EU member countries to implement an FDI regulation, and the catalog of critical business sectors to be reviewed shall be extended. Next slide, please. Just to give you some figures, in 2024, we had in total 223 cross-sector and 38 sector-specific, so defense-related cases under review. Next slide, please. And you see from the chart on the right side, the development in 2020, we have an increase since then from the just national cases, 306 in 21 and 22, a little bit lowered in 23 and 24, but stable on a much higher level than we had before. By the way, USA is the by far biggest investor that fits to what Harvey said into Germany. So that you see on the left field. Next slide, please. So the development, that's perhaps also one point that sublines what I said in my first part. Even if we have several cases under review, you see in 24, you see the right side, the chart, in 24, only 8 cases had in the end restrictive measures imposed by German authorities. So what I said is, even if there are cases under review, more cases under review, the outcome still is that most get green light for the acquisition. Next slide, please. Final one. And the outlook, I would say, due to the EU screening regulation, there will be further tightening of the laws in that respect. it is unclear whether also, let's say, economic aspects will be considered. So saying, even if it is critical, but it saves or protects labor, that then this transaction gets green light. Currently, as I said before, this is not the case, and the authorities only clearly purely look to the question whether it has an impact on security or not. Thank you.
Thank you, Bodo. So before I hand it over to Harvey, I'm just going to announce that the same question that we're asking our speakers is going to be in a survey, so we get a sense of how other jurisdictions are also viewing FDI clearance, and if they can confirm that it has become more frequent in the past 5 years. So you'll see that question on the screen shortly. So Harvey, what is the trend like in the USA?
Yeah, here's the trend. Interestingly, we're having fewer filings. There were about 265 filings in 2024. That was actually fewer than 2023 and 2022, a little bit of the opposite of the trend we're seeing in the European Union. Nobody knows for sure exactly why that is. A contributing factor is China continues to be a substantial investor in the USA. But the boom times of 5 to 10 years ago, when there were a huge number of transactions and huge dollar amounts, have decreased somewhat, although still very substantial. I will say, though, that the trend may be towards more notices and more reviews because we have new developments this year. As you may be aware, we got a new president this year. President Trump took office, and one of the things he has done was implement an America First investment policy, which speaks to foreign direct investment, calls for more enforcement, calls for some streamlining of the process, and some other developments in that area. I expect there will be more assertive enforcement going forward. Historically, CFIUS has focused its resources on doing the reviews and less so on looking at transactions that were not reviewed. I think we're going to see more enforcement, in particular in the real estate area, which has received some attention, but not as much attention in the past. The concern used to be that an adversarial country might use real estate close to a military base to make visual observations or to intercept communications. Now with modern warfare techniques, I think we also have the concern that an adjacent real estate could be used to launch drones and make actual attacks on military facilities. So I would expect there to be more CFIUS enforcement and more filings going forward.
One last question for our speakers. Since FDI clearance is more and more needed, is your firm structuring itself in a different way? Is your M&A department having an FDI specialty group? Or are you even using lobbyists or other professionals that may help clients reach out to the government directly? Ning, is that happening in at Chancebridge?
Ning,
I'm
you're
asking.
on mute.
Ning, you're on
You're
mute.
muted there.
Sorry, no, it's okay. Yeah. No, actually, my answer is no. In China market, there is no kind of lobbyist service publicly on the market. So maybe there are several consulting firms to do a kind of a communication service to help the clients to to do FDI clearance, but not like the formal work service or something. So in China market, there is a very clear division between the legal work and the commercial work. So for law firms, we're not doing this kind of service for our clients. However, according to our practice experience, most clearance works a law firm can do. For example, our firm help the clients to, to do the FDI clearance by preparing the relevant documentation, and we help clients to communicate, of course, on the legal side, to communicate with the government department, and also help them to explain the business background and also other things. But this is not outside of our legal service. So
Thank you.
yeah, my answer is that lobbyist is not common in China market.
Thank you, Ning. Bodo.
Yeah, in Germany, this kind of work is completely done by law firms. So we prepare notification to the authority and prepare the relevant documentation. We are in contact with the authority. This is all done by law firms. So lobbyists, to use lobbyists is really, really uncommon in Germany. It always has some kind of a bad taste to have somebody in, using lobbyists. And as we have, let's say it's very strictly outlined in the law where to go, which are the preconditions, that's lawyers' work. Internally with our firm, we help our clients in M&A transaction. In every M&A transaction, this is an issue which needs to be checked. This is done by myself. To be honest, I'm the head of the department running that foreign trade issues. So even a colleague of mine having a M&A transaction, he comes back to me and my team, and we check that internally. Thank you.
Harvey, we have about 1 minute left, but
Right, I'll use it. Similarly, in the USA, lawyers run the process and prepare the filings. For sensitive matters, sometimes it makes sense for clients to use a specialist firm that has a large department that deals with foreign direct investments. Sometimes those firms have people that used to work for government or even work for the CFIUS committee. And so depending on the circumstance, we'll steer the client towards the best possible resource. It is sometimes the case that we involve public relations firms or lobbyists or others to assist, but that has to be handled very delicately, because if not handled well, it will not be well received by the staff at the CFIUS agency that's reviewing the application. So yes, sometimes, but carefully.
thank you. Thank you all for being with us. And the slides will be available as well as a recording of the webinar. It will be sent to you because you registered to the event. There will be an Ally Law Latin America FDI event. So if you want to continue discussing this and exploring legislation around FDI, you're welcome to register. We'll have we'll let you have the link to the registration page. There are many more things we'd like to discuss. For example, how to draft an SPA that addresses what happens if the FDI decision includes commercially unreasonable conditions. That would be an interesting part 2 of this conversation, but we're happy about the informative scenarios that we've explored today. So thank you very much to our speakers and for Ally Law to organizing this. Bye-bye.
Thank you.
Thank you. Yeah, thank you. Bye-bye.